We never want to encourage somebody to go ahead and get a divorce if they're not sure that that's the step that they want to take. But certainly if you've been served papers, you would have to answer those papers. There's time restrictions with that end of it. So we would certainly recommend that you meet with an attorney right away if you've been served. If you're still contemplating it, we would be more than happy to meet with you to explain the process should you decide to go that route. With litigation can be somewhat of an expensive process, because if it's a case that's contested, and meaning that the other side doesn't really want to agree on many of the terms of the divorce, if you have children, there's going to be the issue of time sharing, there's going to be the issue of child support, parental responsibility. That can get fairly complicated if the parties are not in agreement with what should occur with the child or children. For example, if one party wants to have primary, maybe 70% rather than 50-50, and the other parent says, well, no, I want 50-50, we want it to be even. And there's going to have to be an argument made that the 70% should be given for, that one parent is better, or an argument like that. So you're going to have to prove that somehow to a judge in a trial or in another capacity. So oftentimes, if we're going to go that route, I would recommend to a client that they have some sort of expert advice, or we're going to have to do depositions. All these things cost money. So, I would highly recommend having some money saved up before you proceed to that, just because the costs can rack up fairly quickly on the end of court costs and expert fees. Those don't go to the attorney. So we can do a flat fee type of arrangement only in a limited circumstance in which the parties can agree on most of the terms. So we can actually do those for clients at a very low rate, only in that limited circumstance. Family law is honestly one of the areas of law that I would never recommend doing without an attorney, just because of the procedural nuances. I've had so many clients come to us and they tried the process pro se or without counsel and ran into so many obstacles, and so when they ended up coming to us, it probably cost them more money because we had to go back and amend things, and we had tons of documents to go through. So it really just made things more difficult for everybody, delayed the process. So I wouldn't really recommend that unless both parties again have agreed on everything. And then I would still say to come to an attorney, or particularly our firm, because we can do the low flat fee. And it'll cost you $1,500 and out the door. So it's just, and it can be done much quicker, because if you have an attorney, we can have a hearing much quicker than if you were a pro se party doing it on your own. It's just, there's so many benefits to doing it that way, and then you'll have a really good final judgment that has all the terms in it that you would want to avoid any modifications in the future, or contempt hearings, which is just going to cost you more money and headaches in the future. So that would be my recommendation. When you get married, basically at that point, anything that is incurred, whether it's property or debt, is going to be considered part of the marital estate, and then subject to an equitable distribution, or 50% going to wife, 50% going to husband. Of course, if you enter into some sort of prenuptial agreement, all of that can be eradicated and not subject to those rules. Not many people do prenuptial agreements, but I do recommend them if you want to avoid a lengthy divorce process. Well, if you are getting divorced and you have children, it would be a contested or uncontested divorce with minor children with property. So the pleadings that the Florida courts provide, there's standard forms for family law that you can actually find online, and it does designate the various types of proceedings. So typically, if start to finish, you're going to have in a final judgment the issue of the minor children, so the time sharing, the child support, and then the distribution of property. So everything will be included in that final judgment. In some instances, the cases have to be what's called bifurcated or separated. Let's say there's a domestic violence issue and there's an injunction, and the parties are not allowed to see each other. I had a couple cases like that where the judge would bifurcate the proceedings so we could get a quick hearing on the issue of property and maybe restoration of maiden name, simple things like that. And then we had to have the other aspect of the case at a later date and time, because the injunction, which would be a separate type of proceeding altogether, or if there's a criminal proceeding, that the judge in that case may have had mandates regarding, the husband is not allowed to see the child or the wife is not allowed to see the child. Well, we wouldn't be able to, the judge in the family law case wouldn't be able to dispose of the case concerning time sharing because of the criminal case pending. So oftentimes that part of it will just be held off until the criminal case is resolved. So that would be like a bifurcation case. And believe it or not, these injunctions are so common nowadays. It's sad to see, but it's almost, 1 out of 2 have some sort of domestic violence issue or an injunction issue, which has child support and time sharing included with the injunction. So it kind of complicates things with the family law case. As far as what cases our firm handles with respect to family law, it's a pretty broad subject area. We obviously divorce, whether it's contested or uncontested. And then there's any of the child support cases, whether it's a modification or contempt or enforcement. Those cases don't have to be divorce related. And then paternity as well. Adoption, we've handled step-parent adoptions before. Those are a little bit more straightforward and quick as opposed to another type of adoption case. We also handle domestic violence proceedings, whether it's an injunction and you're the petitioner and you want to serve your husband or boyfriend or whomever for some sort of violence, stalking, harassment, and you feel like you're in imminent harm, then we would be able to assist you with that in filing the petition and attending the hearing. Or if a client was served, we could also assist with that. So if you are going through a difficult time and there's a family law issue pending, or you're not sure what to do next concerning something domestic relations wise, please call us at 407-476-3437 and we can schedule a consultation for you. You can come into the office and discuss your issue, or you can visit our website, www.fiercelaw.com, and send us an inquiry that way, and we'll be happy to assist you and see if there's a case or let you know at least what your rights and remedies would be. One nice thing that we do that it's a little bit different from, I would say, most of the other family law firms is the consultation is completely free, and sometimes they do go almost an hour, so we never charge for that, and we don't want to hinder or obstruct anybody from coming in, so that will be free.